Hi, welcome to My Court Coach. I'm Jalen, and I'm going to be your instructor as we talk about declarations. Now, declarations are used to support any motions that you are filing. So a motion can be a request for order, or it could be a request for a domestic violence restraining order, or even a request to establish paternity, and the reasons as to why you want to have a paternity test, for example. So declarations are, again, needed to support your request and asking the court why you need a certain relief. Now, there are guidelines as to how you should prepare a declaration. These guidelines are pursuant to the California Rules of Court, and they could also be pursuant to your local rules of court. So you would need to check your local rules of court to see if they have any additional guidelines as to how do you prepare your declarations and what needs to be written inside your declarations so that it's considered by the court at the time of your hearing. Now, declarations, they have to be based off of personal knowledge. A lot of times, individuals write a lot of statements that they just heard from other parties, or they heard from their child. By law, pursuant to the evidence code, they are not actually supposed to be admissible statements because they do not have personal knowledge as to what is being stated if and only if what's being stated is about an event that that person had heard. For example, let's say somebody came to you and told you something about what they had heard. Are you allowed to use that sort of statement in your declaration? Most likely not. There's exceptions as to in what context you're receiving this information, but it's considered what they call hearsay. So the court is not supposed to consider that statement. But the court is only going to know whether it can or cannot consider that statement unless somebody makes an objection. So if nobody makes an objection as to that statement that's written in the declaration, then it is going to come in as evidence and it will be used against you. Make sure that they are, in fact, based off of personal knowledge. So your own knowledge, what you saw, what you did, or if you did observe something where somebody did say something like what they call excited utterance, like somebody got hit by a car and somebody said, "Oh my God, I'm sorry," things like that, then yeah, sure, you can include it in your declaration. But for purposes of your family law proceeding, most of your declarations are going to be about money and children, nothing else. So it's really going to be about what you saw in statements or your conversations with the other party, your conversations with their attorney, maybe even your own conversations with your own attorney or specialists that are assisting you in your divorce, like your financial accountant, for example. So those individuals we can certainly have testify also on your behalf by writing their own declarations too. Likely your attorney is not going to write a declaration on your behalf as to any observations of the details of your case, but they will write declarations in support of your request for attorney's fees, for example. The best thing that you can actually do is draft the declaration for them so that it's written in a way that you want it written. And all they have to do is review it and sign it. Now, if you don't have to do that, you could also have the declaration written by that individual in their own terms, and you review it and see if there's anything in there that you think would be faced with an objection at the time of the hearing. Now, commonly in child custody and visitation cases, you always have the children's statements in the declarations. And I think one of the things that a lot of individuals fail to consider is that they are in fact kids. These are minor children, and they're your kids who love you and want to support you and don't want to feel neglected by you. So when you draft a declaration and you write their statements in there, one of two things can happen. One, the child, more likely than not, will find out by the other parent. I mean, if you have a parent that is not even abiding by the no negative statements rule, or the rule about how the children should not be exposed to the court proceedings, there's always that happening in family law cases that involve children. And so in those particular cases, your child, more likely than not, is going to find out that when they made that statement to you, perhaps in confidence, is now written in the paperwork. And so that diminishes your trust, even though you're doing what you thought was best, by telling the court what the child had said, maybe about the other parent or how they're feeling or how they want to spend more time with you. But yet now they've thought that this was something that they can trust you with, and now they know that they can't. They know that they may not be able to come to you because you'll just write it out on a declaration. So you're really putting your child in the middle when you do that sort of thing. When you do tell the court, this is what my child said. And then in the alternative, kids love to tell whatever it is that their parents want to hear, or whatever it is that's going to make them get what it is that they want. This is true for all ages for children. So the parent or the child can come to their parent and tell them, you know what, Dad, I want to stay with you. I don't want to go back to Mom. Can I just stay with you for the weekend? And then they go and actually complete the exchange, because a good co-parent would talk to their child and say that actually we have some court orders in place and it's not fair for your mom to not be able to spend time with you during this time. So let's just make it up to each other when I see you next. And, I love you, and, I'll see you next time. And you could always contact me via phone if, whenever you miss me, things like that. That's what a great co-parent would do, versus calling the other parent and saying, our child wants to stay with me a little bit longer this weekend. Is that okay? Or having the child call their parent and say that, again, involving them in adult issues. Anyway, so then you do the exchange, and this exchange is with the other parent. And the parent is like, oh, how was your day how was your weekend with, your dad? And the child goes, oh, I missed you so much, Mom. Like, I really couldn't wait until I could come back. I really wish I didn't have to go to Dad so often. This happens so many times because they're kids. They know that you're going through a divorce. They know that you're going through a separation. And to write what they're stating to you in court to support your side for child custody and visitation modification or establishment, it doesn't really help you. I mean, I think the judge, when they read those sort of statements, they don't heavily consider it. Unless they're statements of abuse, and you receive those statements and you're writing those statements in your declarations, and that's of course appropriate. But if all you did was just take those statements and put it on a piece of paper and did nothing else with it, the court is also may not necessarily take it as seriously as you would like them to, because you didn't call child welfare services or anything else. So I just wanted to point out the distinctions for the declarations and how it's important to really write what it is that you personally know without involving your children in that, unless it involves domestic violence or abuse or anything like this. But aside from that, it should just be based off of your own interactions with the other parent, or your own your own ways of finding out about the other party's income or what they're doing from time to time, instead of finding a job. You know, those sort of declarations, those are appropriate, and the court has to consider them. So your declarations are also supposed to be in lieu of live testimony, meaning instead of you sitting before the judge and telling everything to the judge in court, you're using the declarations to write out everything that you do want to notify the court about. When you do that, then the court has to either accept, your declarations if you move it into evidence. I mean, that's the proper thing to do, is to ask the court to admit your declarations into evidence, because just because you write your declaration does not automatically make it evidence before the court for it to consider for your motion. And it actually varies from judge to judge. By law, they're not supposed to admit it unless you ask for the court to admit your declaration into evidence for it to be considered by the court, as opposed to you testifying in the courthouse. So what does the California Rules of Court say in order for you to prepare your declarations? So along with your request for order or responsive declaration, and you can watch a different video on what those forms are, a party must file a supporting declaration with the court clerk and serve it on the other party. The declarations must comply with the following requirements. The length of the declaration, included with the request for order or a responsive declaration, must not exceed 10 pages in length. A reply declaration must not exceed 5 pages in length. So a responsive declaration is literally the other party's response to your request for something from the court to actually happen. And the reply declaration is reserved for the person that filed the motion or the request for order. So that declaration is typically filed 5 court days before your hearing, and you essentially have the last say. So the other party can't file a responsive declaration, although it does happen, but they are not supposed to file a reply declaration, and you can always ask the court to strike that reply declaration because responding parties do not have a right to reply to your reply. There's no rules of court that support that. Maybe your local rules support that, and you should check again with your local rules to see if that's something that you can do. But it is the person that is filing the motion, they have a declaration to write, and it can't exceed 10 pages. The person that's responding to the motion has 10 pages as well that they could go ahead and submit to the court. And then the moving party also has a chance to reply to the responsive declaration, and they can only do that within 5 pages. So those are the differences between supporting declarations or reply declarations. So the declaration is of an expert witness, or the court grants permission to extend the length of a declaration. So that's if you do in fact need a reply declaration longer than 5 pages in length. So it's an expert witness, and the court grants permission to extend the length of the declaration. Now the format, and content of declarations. So the form and format of each declaration submitted in a case filed under the Family Code must comply with the California Rules of Court 2.1, etc. A declaration must be based on personal knowledge and explain how the person has acquired that knowledge. The statements in the declaration must be admissible in evidence. So to go to point B1 here, the form and format of each declaration. So the form is actually here. It's called the MC-030. And this is the form that you can use. It's approved by the Judicial Council. that will help you draft your supporting declaration or even your reply declaration. I know it has the term declaration. It doesn't need to say the words reply declaration. It doesn't need to say supportive declaration, or even it doesn't necessarily need to say responsive declaration. It's a declaration, and you could write in here saying that, I, the petitioner, provide the following reply declaration, or provide the following supportive declaration to my request for order regarding a modification of child support, for example. That sort of language can be written in here. And if this is not enough space for your declaration, then you can also attach this, the MC-025. And this MC-025 is going to be attached to your MC-030. And you can just write attachment MC-030. And you can continue writing your declaration. And it says right here that you could even note the number of pages. So if you started off with this page, this is page 1, and you're going to complete the heading and put in the case number and all that good stuff, and then you're going to start, your declaration. The best way to start a declaration, by the way, is because it says that it must be based on personal knowledge and explain how that person acquired that knowledge. You can start your statement saying, this reply declaration is based off of personal knowledge, and this is how I acquired it. And you could go down and explain the incidences that you want the court to be aware of, any text messages or anything that support your statements. You would go ahead and explain that here. And then these statements in the declaration must be admissible in evidence. And so that requires you to be a little bit familiar with the evidence code. And the best advice that we could give is make sure that it is based off of personal knowledge, something that you saw, a conversation that you had, but it can't be a conversation that you had with somebody that had a conversation with somebody else. So it's a conversation that only you and this other person had, or something that you only saw. Those are the only sort of statements that should go inside your declaration. And then there's the exceptions that you could find under the evidence code to assist you with those declarations to make sure that it's admissible in evidence. Once you have your perfectly written declaration that is based on personal knowledge, and you have, this page, and let's say you attach, 3 of these attachments to explain your position, and now that's actually a total of 4 pages, right? Because you have your declaration sheet and then 3 of these attachments. And so you would write, 4, and then you would write, this would be page 2 or page 3 or page 4, because they are attachments to your MC-030. And it says if the item that this attachment concerns is made under penalty of perjury, all statements in this attachment are made under penalty of perjury. So what that means is that you don't have to continuously write the statement over and over again, because all declarations are prepared and signed under penalty of perjury under the laws of the state of California, and that the foregoing is true and correct. You have to date it, sign it, and then say whether you're the petitioner or the respondent. Plaintiffs and defendants are not parties in a family law matter. Only petitioners and respondents are, or even if it's a witness on your behalf, then they would go ahead and complete their name here, or, well, they write their name here, but like they would write that they're a witness there or an expert witness. So that is how you would complete the declaration. Now, earlier we were talking about objections to declarations. And if a party thinks that a declaration does not meet these requirements, the party must file their objections at least 2 court days before the time of the hearing to that declaration by also using their 10 pages. And then the moving party, which is the same person that initiated the action or initiated the motion, they can then write a reply declaration, and that doesn't exceed 5 pages in length. But then the other party, the one that completed a responsive declaration, they don't and cannot have any statutory, they do not have any statutory rights to complete a reply to your reply, right? And you have the final say. Now here is the exception, because objections are not considered declarations. They're not based off of your personal knowledge, unless the objection is that the person lacks personal knowledge. But the objection now, you can do it in writing 2 court days before your hearing. So if your hearing's on a Thursday and there's no holidays between the Monday and Wednesday, then your objections are due to the court on that Monday. And it doesn't have to be in writing, but it's best practice to do it in writing. And so you can just use the attachment form if you had wanted, since it's not necessarily a declaration, or actually it's not a declaration at all. Then you would go ahead and just write, objections to declaration in support of petitioner's request for order, or whatever it is that you're objecting to, and just identify what those objections are. And then at the court, the time of your hearing, the court can in fact not consider the evidence or the statements that's written in the other person's declaration. So it's important for you to raise those objections when you can, and the earlier that you do it, the better it is. Then C2, if the court does not specifically rule on the objection raised by a party, the objection is presumed overruled. If an appeal is filed, any presumed overrulings can be challenged. So when you go to court and you are objecting to certain statements in a declaration, and the court doesn't automatically rule on it, then it would be considered overruled. That means it will come into evidence. The court will, in fact, consider it when they're making their findings and order after your hearing from you and the other party. So if you're sitting there and you're raising this objection and the judge, ignores what you're stating, then the court is overruling your objection. So you can keep that in mind. Then there's also California Rules of Court 5.112.1, and this is the declaration page limitation and exemptions. So judicial counsel form portion of a declaration does not count towards the page limitation to a declaration, as specified in the rule that we just discussed. And the following documents may be attached to your forms: the request for order form or responsive declaration form, without it being counted towards the page limitation for declarations. So an income and expense declaration, a financial statement, a property declaration, the exhibits attached to declarations don't count, and then a memorandum of points and authority as well. They won't count towards the page limitation for declarations. Review the local rules before preparing your declaration and make sure that it is signed under penalty of perjury. Make sure that your attachments also have the page numbers that will be attached to your MC-030, and you're going to take these forms and make 3 copies, file them with the court, and make sure that the other party receives a copy of your declaration. And you're also going to make sure that the court has a proof of service of the declaration on file for you. We hope that you found this video helpful, and best of luck.